American going to keep the American.
Sir, you may please start the session.
Okay, thank you. Good afternoon. On this, I will be taking only a part of this session today. And although it is mentioned first about drafting a well-rounded specification at that title, I'm going to first start with talking about the legal requirements of a patent specification, and that is what I'd like to start sharing first. So there are quite a few slides, and the time is short. So I will go through at a little faster pace than yesterday, right? Yeah, please. Guys, you can see you can see the presentation? Are you able to see the first slide? Yes, okay. Right. All right. So the topics that we will cover is legal issues, drafting, and then some tips for drafting of a patent specification, question and answers. This normally is a topic that takes about a week to cover, but I'll try to cover it in an hour, right? The next topic. I should move.
What is the slide you see? Is it the topics covered?
Yes.
Yeah. Okay, so it's okay. No,
All right. Yeah.
This is you have to, before clicking, you have to see that your cursor is
Right. All right. Remember that a patent specification, the important thing is that a patent is granted. This basic is what is called the quid pro principle of the patent system. The quid is the knowledge that you disclose to the public. The quo is the monopoly that is granted. And the pro is the basic patent application or the patent system, which gives you the quo for the quid, which is the knowledge. So it's now, therefore, if the disclosure in the patent specification is insufficient, then the inventor cannot or should not get the patent monopoly. Therefore, what is the purpose of this quid pro quo? That once the patent expires, the invention should become available to the public for commercial exploitation. Important thing is without the assistance of the inventor. The inventor should not be there to assist a person who wants to exploit the invention after it is expired. As you probably are aware, the lifetime of a patent is 20 years in most countries now, and therefore after 20 years, the invention becomes what is called generic or sui generis, and therefore it comes in the public domain. This complete disclosure requirement is found in Section 10 of the Act, which requires the specification must be fully and particularly described in the invention, and the method by which it is to be performed. Generally, what the patent requirement is that the best method known to the applicant when he was filing the application should be disclosed. So if after filing of the application, a better method becomes known to the applicant, he is not bound to disclose that. Then there is another provision which is called enablement, which means the patent application the invention must be enabled in the patent specification. These are the requirements and finally we have the claims, and what we discussed yesterday, the scope or the claims define the scope of the invention. They plot the field, the area in the field where this invention or the idea relates. Okay. Now, the contents of the specification, I'll run through this because we've already done this. There must be a title, less than 15 words. Drawings must be there if the specification or the invention can be drawn. And sometimes the patent office may also ask, the controller may ask for a model or a sample to be furnished, and we have sometimes furnished these samples to the patent office. Okay. The section 10.4 requires the full and particular disclosure best method, and the specification must end with the set of claims defining the scope of the invention for which protection is claimed. And of course, at the end, there must be an abstract, which is for 150 words. The purpose of the abstract is for providing this technical information. As you know, every year, for example, last year alone, about 6 million patent applications were published. Everybody cannot read the 6 million patent applications. So but what they should be able to read at least are the abstract. So this abstract has to be, in India, the requirement is that the abstract has to be 150 words. Other countries don't have such limitations. Okay. The claim, now this is another legal requirement, is that the claims must relate to a single invention or a group of inventions. And in India, this is almost like the European pattern. It must relate to a link to a single inventive concept, which should be clear, succinct, and must be fairly based on the matter disclosed in the specification. These are the legal requirements of the specification. And please read section 10.4 and section 10. In fact, the complete section 10 should be read very, very, very carefully when drafting a patent. And this is the section where all patent attorneys are trained. We train patent attorneys to implement section 10. Drafting of a patent specification, therefore, means implementing section 10 of the Patents Act. All right. This requirement is that there must be a unity of invention. The patent specification must relate when it is finally granted. See, every application for a patent the patent office will give it only for one invention. And as I said yesterday, we can, if there is a unity objection, the application can be divided. All right. Now the whole idea is that multiple patents should not be obtained at the same price. But by filing divisionals, I can delay paying the price for multiple inventions by using this facility available at the patent office. Now we come to the other aspect: is how do I draft a well-rounded, which means the specification for which I will get a grant. Remember, what is the function? Who reads? Important thing is who reads the patent specification. And therefore, important thing is that the patent specification must be prepared for the person to whom you would want it to be read. Firstly, it is the controller. That's the first person who reads the patent specification and grants the patent. And thereafter, my patent specification would be read by a judge in the court in an infringement action, or in a revocation action. It will also be read. Therefore, these are the people who would read, and of course, my competitors will read it if they want to try and bypass my patent and come up with a route which is different. Now, these are the certain important issues in a good rounded specification. My detailed description usually must start from being as broad as possible, and finally it must become as narrow as possible. All right. The figures will also follow the same pattern, which means my first figure should be the broadest possible view of my invention, and the later figures would drill down to narrower and narrower elements of the basic invention. Now, it is generally I like to label. This is although this is not mandatory. You generally label the entire invention as 10 or 100 or 200 or 300. And the numbers generally, when we are drawing, I like the elements or to be increased by 2, which means we write all even numbers. Why even numbers? This is merely by convention, because sometimes when you want to describe an element which you haven't numbered, I can then put it in place in between. I don't have to add it in the end. That is why we write even numbers, so that we can add other elements later on during prosecution. All right. Now here are the steps for drafting. There are in fact a total number of 17 steps for drafting of a good specification. For one is, of course, I spot the invention. I must first find, that is the most important element in drafting a specification. I must spot the invention. Once I've spotted it, then I try to generalize. For example, if it is an aromatic compound, I would like to generalize it to for other aromatic compounds, which may be possible. If for example, we are saying it is powered by a mechanical method, by mechanical linkages, I will speak of hydraulic linkages, I will speak of coupling linkages, different types of couplings. Then once I've done these two, I will determine what the field. Remember, I have to determine what is the general field of the invention. Then thereafter, I decide on the terminology. For example, if it is an engine, I may want to describe the engine as a power source instead of just calling it an engine, right? Now, if it is, for example, if it is a chemical compound of a particular nature, I may call it an agonist or an antagonist, or I may decide on the terminology, and that terminology must remain the same throughout the invention. Then once I've done that, then I must define my terms in the invention. Whatever terms I'm going to use, particularly elements that I'm going to claim in my claim, these have to be defined. Thereafter, I've tried to find prior art and identify the differences between the prior art and the invention. Once this has been done, there must be a purpose. The purpose is we call them the objects of the invention. Currently, according to US practice, drafters in the US don't include objects, because these objects can come in the way of a proper drafting. All right. Thereafter, once I've determined the objects, I actually start drafting claims. For doing a good specification, we draft a rough draft of the claims. Now, I paste these claims in the body to form a summary of the invention. So these claims are then mapped so that my claims, therefore, are completely enabled in my specification. So the controller cannot say that you haven't described any element of the claim in your specification. So I actually paste it twice. I paste it in the summary, and I paste it also in the detailed description. All right. Well, this is item number 13, pasting claims in the detailed description and modifying it according to this. According to the requirement of the description. You then add, there may be a possibility that you can add drawings. One by one, you can start adding the drawings, arrange the drawings of the figures in a particular sequence, decide what is the sequence. Then you start drafting the detailed description with reference numerals. Remember, the requirement is that my drawings should not contain any descriptive matter. So, for example, if there is an engine, it will bear a reference number, some reference number, or I may call it E, or I may call it a reference indicia. They also call it reference indications. But reference numerals should be there, and these will replace words. Now, it is good practice, and in some countries a mandatory practice. In India, the controller will always ask you to insert the reference numerals in the elements of the claims. Europe is mandatory. Once I've done this, Then I write the introductory part of the description, which generally is a description of the prior art and the objects. What I've written earlier in the background and what I've written in the objects of the invention, this becomes my introductory part of the description. And then I also write the abstract using reference numerals. And now check after that whether the claims and the description are tied together. If you have done these two pastings, which means you have pasted this, sorry. If you have done this, if you have pasted claims in the body to form a summary of the invention, and you have done, you have you have pasted the claims in the detailed description, you can never go wrong with tying up my specification and the claims. This is one trick or one aspect that I learned the hard way, and it's part of my practice now almost universally. Now let's say some more tips for drafting. All right. The embodiments, examiners may limit a claim to a preferred embodiment and invalidate that there are broader than the disclosed embodiments. Therefore, the more the embodiments that are there, the better. I need to give as many embodiments as possible so that the examiners may limit a claim to one of the embodiments. But if there are no embodiments, then I don't have this. Ability to do so. Now, try to anticipate all competing products that may affect the monopoly. Now, this is an important part that you have to think out. This is where the person who's drafting, he has to think what is the possibility or what are the possible competing products that may come. For example, if I'm speaking of inventing a new car, I will now have to think of that possibly, yes, the engine may be replaced by an electric motor. So it would then become a competing product. All right. So I need to anticipate all these factors. I need to think. That is where the vision of a patent attorney is very important. Right. Here I'm taking example of a few cases. For example, the claims spoke of a plurality of openings that were on adjacent side walls and end walls. The word adjacent side walls was there in the claim. Now, the way the infringing device did, the openings were only along two walls, which means opposite walls and not adjacent walls. And he got away with this. And there was only a single embodiment where the openings were shown only on the end walls and the side walls, which means the adjacent walls. And this, the infringer got away with it because of this a little narrow drafting where this word adjacent caused the problem to the patent holder. All right. Therefore, now remember, claims are the most important part of a patent specification. They protect the invention. Now, therefore, this is important, and all claims should be construed, and they are understood solely by the specification, and therefore the specification, as we said yesterday, becomes a dictionary for elements in the claim. All right. Now, the primary function of the rest of the patent, that is the rest of the specification, is to support the claims. And that is, in light of the present law, that is how it stands. The specification is merely a dictionary for elements or a description for the elements which are disclosed in the claim. Okay. Now, for example, in this particular case, what happened was that the original claims claimed a sofa, and there was a control that was mounted on a console. That is how the original claim read. The control was mounted on a console. This was when the original claim was drafted. Later on, what happened was that the patent or inventor thought that he could have this control on any position on the sofa. This is the type of a sofa where you have a lever and probably it can be tilted backwards, or the legs can rise. Now, what they thought of was initially it was a console, but now this was later on the patent holder amended it to broaden the claim and said that the control location could be at any position or anywhere on the sofa. But now it happened that the person who violated this sofa, he mounted this particular control for tilting the sofa, not on a console but on the sofa itself. Now, in the court said that originally the patentee had actually intended to limit the control position only to the sofa, to the console, and therefore now this extension that was done was illegal, and therefore it was contrary, and the court finally held no infringement, because this was not what the inventor originally had conceived, right? So never describe the invention as a whole, or characterize the invention. Now, this is as a whole, never describe it. Always describe it in parts, in limited parts. Therefore, when there are several inventions where I've seen that the whole invention has been described. Always describe this in parts. This is I'm not able to totally explain this concept, but it must always be described in little parts. Describe, for example, if I'm again taking this concept of the body yesterday, which I showed yesterday. Describe the body of the bottle in one. Describe the cap in a second. Describe in a different paragraph the methods by which this particular cap closes the mouth of the body, and describe the ring separately. But never describe in one paragraph, write the entire invention. Now, what happens is that if that happens, then there is a possibility that the court, remember, the reader of the specification, the patent or controller will fully understand you. But remember, one person for whom you are writing the specification is also the judge, who is most probably not a technical person. And because the judge is not a technical person, if you describe the whole invention in one paragraph, he will read only that paragraph and try to understand the invention in that manner. And it may happen that paragraph may be very limiting. Therefore, you describe the invention in different parts, although it must be clearly identified and limited to specific embodiments of the overall invention. Don't describe that the invention is so and so. All right. Now, for example, this was an invention where there was a whole case. Please note down this case. It was a case of Honeywell. It is, of course, an old case of 2006. Honeywell International versus ITT Industries. If you don't get this case down, I'm quite happy to share it with you. This was one of those cases of quick connect, where the whole invention was described, and the invention was identified in the specification only to be a fuel filter. So although the claim was directed to a fuel injection system, in the specification, the invention was identified to be only a fuel filter. A fuel filter with only one embodiment was described. The court said that yes, I am going to, although this was a fuel injection system which was claimed, the inventor wanted to claim only a fuel filter and not the whole fuel injection system. And because the fuel filter was not part of the claims, did not cover the infringing article. It is a little complicated case, and all, but I've really taken it here to say that don't describe what your invention is in the specification in full. Describe it in parts in different embodiments, and write that in one embodiment it is this way. Therefore, say that. Remember, if a patent specification says that a particular element, ingredient, property, or characteristic is important, that statement will be read by the judge that this particular property, this particular element is important. And therefore, if that important element or that important property is not there in the infringing article, you are other words like necessary, essential, required, these words also act as limitations and should be avoided when drafting of good patent specifications, generally for the purposes of stopping infringers or competitors. All right. Now another required case. This is another required characteristic. I'll give you an example. For example, this whole patent specification was addressed to this is another case of 2006 where it spoke of a alphanumeric keyboard having a substantially full set of alphanumeric keys. Now in the prior art, they spoke of the patent applicant. He spoke of these cell phone keypads are extremely slow, awkward, error-prone, and not appropriate. So these words were used in the prior art for text transfer on a regular basis. So because this was actually spoken in the prior art that cell phone keypads, which means your 12-digit keypads, which are normally there on your cell phone, are not good. Therefore, the infringer used this digital keypad, the 12 digital keypad, and got away with it, saying that although the claim spoke of alphanumeric keyboards, because the infringer had used a 12-digit keypad, which was the cell phone keypad, he got away with infringement. So sometimes we have to be very careful when drafting, not to include these kind of limitations, right? Now here there was another kind of claim language where the word or was used. That means the word or was used in the claim. Yesterday somebody asked me about the word or. So now what happened was that in this particular patent specification, the claim spoke of searching said component. Please read. I'll read this a little carefully. Searching said components in memory for the component that meets pre-selected magnitude or frequency criteria. So they said that this was a limitation. My components in memory should meet either amplitude or frequency. Now in the infringing article was able to search the components both for magnitude and frequency. So instead of or, the infringer provided a methodology where both magnitude and frequency could be searched for, and therefore the rest of the elements were the same, but this element was the searching element was different because it could do both, and the court said, sorry, this is not an infringing product. Okay. Now, therefore, this is the District Court of Kansas in which this case was heard. I'll just read out the or was read to mean a choice between either one of two alternatives, but not both. This is what the court said. This was a choice, or meant a choice between either one of two alternatives. And that is why when we spoke yesterday, I should not have the we or the word or is a little dangerous way to draft claims. Now, the accused device was performed the analysis of both the strongest and the fastest signals, which means both magnitude and frequency were selected. Therefore, therefore the court said, this guy does not infringe. All right. Now, I will ask, I'm quite happy to take any questions in the next few minutes. If they have any questions about yesterday and today, please feel free to ask before I ask Mr. Patre to take over the next session.
Hello, sir.
Yes, yes, sir.
Thank you for this. I have seen like in specification people use word surprisingly. So
Yeah,
like, what is your take on it? Like, can we include like it will harm any
yeah,
process?
yeah. In the claim, generally the word surprisingly is not it's not encouraged. We would say that the word surprising doesn't have any particular meaning. It technically would not have any meaning, but the word surprising is used generally in office actions. When we reply to office actions, we will say that a surprising result was obtained. A surprising result was obtained by this particular chemical compound or by this arrangement. The word surprising is added in responses to office actions generally to emphasize on the inventive step of the invention. So I would not advise you to add to those of you who are hearing me today. Please do not add the word surprising in any element of the claim. All right.
Sir, I have a question
Right.
for you.
Of course.
Yesterday we were talking about divisional applications. So, sir,
Yes, ma'am.
my question was, if the parent application had two set of independent claims, wherein
Yes, ma'am.
the second independent claim has been divided into a new divisional application.
Yes, ma'am.
Now, sir, can we add new dependent claims in the divisional application?
Uh, I have done it sometimes where I am able to I am able to break, for example, if there is a Marcus claim in the parent which came into the divisional, I may want to emphasize and divide the Marcus into several elements. It all depends upon how. So a Marcus claim can be further subdivided into its elements if, and I would do that if there is some additional additional advantage of having that element separately. But generally, typically, my answer would be that you can't have more claims. I can't have further claims, except in a case like I've said, if there is a dividing, there is this kind of methodology. Now, the way to do that is if you really want to add a few claims extra, I would, within the scope of my original claims, I first add it in the parent. I must add those claims in the parent. If so, I must think out my divisional very carefully. How I want my claims to go. Generally, what I do is in the parent, I would add a few more claims directed to the divisional part, and then divide the complete divisional so that those claims are there in the parent, and I have now divided them and taken it out. That is the way to go about doing such an exercise. But the answer would be it would be very difficult to get away with adding new claims in the divisional, particularly if it is beyond the scope of the original set of claims in the parent.
But sir, one more thing. Nowadays, sir,
Yes,
the
ma'am.
controllers do not allow even dependent claims in during prosecution. So how to go about that? Sir?
No, see, when you say they don't allow a dependent claim, for example, it all depends upon how the claim is worded. I have been able to get a few dependent claims added into the specification, particularly if I'm limiting the number. So assuming that you have 20 claims, all right? I'm sorry, I didn't get your name. You are?
I'm Swati, sir. Swati Chaudhary.
Yes, Swati. Swati, the way is assuming that you have 20 claims, all right? Or your original specification had 20 claims, Swati. Now you have deleted about 4 or 5 of the claims because they were not redundant. Now instead of those 4 or 5 claims, you wanted to file a further divisional claims because you wanted to take out an element. There was a particular element that you wanted to which are there are multiple elements in my claim 1. I want to divide that and take it out of my claim 1, and the controller will allow this. Generally, he allows it if my claims don't exceed my original number of 20. There is they have this kind of rule in the manual that there should not be more than the original claim. So if I remove a couple of claims and add a claim which I want, I am able to add a few more divisionals that way. Sorry.
Okay, sir.
All right.
Thank you, sir.
Sir, I
You're
have a
welcome.
query.
Yeah, of course. Who is this? Give me your
Sir,
name.
my
please.
name is Soumya.
Soumya. Yes, Soumya, tell me.
Sir, it is advised that we are not using or in the claims.
Yes, sir.
But can we use selectively or optionally?
Yeah, optionally is fine. Optionally is a very common and generic term used in the claim. That it optionally contains, which means that is not or. Optionally means that is an option that need not be. See, instead of just to give Swati, for example, this word, if there was for example, in claim 1 spoke of an element that was optional, that claim can be taken down and made into a dependent claim. Optionally is perfectly a valid method of describing something which may be there in the original invention, or it may not be there. So word optionally acceptable, sir.
Okay,
We have also added one mistake that those guys did was there is also what is acceptable is and hyphen or. You will see that in some claims, in some claim drafting, they have allowed and hyphen or and or. So you are giving both options.
okay, sir. Thank you. Thank you very much.
Such a thing would be allowed. Okay, Soumya?
Okay, sir.
All right. Right, guys.
Hello, Parag here, sir.
Yes, Parag.
Yeah, so this is with respect to invalidation and like post grant. So like
Yes.
we have some post grant window period when the
Yes.
patent is granted. When the window period is expired and I want to go for invalidation, then like what would be the approach?
At the moment, this question is before the Supreme Court, sir.
Okay, sir.
The Supreme Court, Parag, is now going to decide whether the IPAB, Intellectual Property Appellate Board, is required to remain, or it will go by the ordinance that was passed by the Government of India. If the Supreme Court says that the ordinance was bad, was wrong, then of course the IPAB will remain, and you will have to file your invalidation proceedings before your IPAB. If the ordinance goes, then you can file the invalidation proceedings under Section 64 of the Patents Act before a high court. Which high court? The high court would be the high court where the patent was granted. That is the first choice. Bombay, Delhi, Chennai, or Calcutta would be the first choice of the High Court in which you can file what are called invalidation proceedings under Section 64. And these would be filed. Now, if of course an infringement action has been filed against you, and you want to file invalidation, then you will file it in the you will file the you can file the invalidation as a counter claim to the infringement action. This is this would be the method of and for the purposes of invalidation, all grounds available in Section 64 of the Patents Act are now available to you for the invalidation proceedings. Invalidation proceedings are a little more difficult than post-grant proceedings. But as you know now, Parag, is this a case that you need to file right now?
No, sir. I am just curious to know, like.
You're just curious to know. All right. Because right now, the pandemic, your pandemic extensions are still going on, Parag.
Yes.
And who knows how long these pandemic restrictions will go on. So today, if you want to file a post-grant opposition, you can file it under the pandemic extensions available. You can say that a few days have gone or whatever, and we could not do it. Give some reasons and make a request make a request for condonation of irregularity of time. That is section Rule 138 application can be filed, and you can file a post grant opposition now. All right. So right now, of course, this is the current situation, and we are all of us are waiting eagerly for the final directions from the Supreme Court of India, sir.
Okay, sir. Thank you.
Right, Parag.
Sir, can I ask you one more question, sir?
Of course. Swati, that is why I gave a little time, and I will also have one section tomorrow at the end where if there are any more questions, and please you have my email ID. I think it's there in this in this slide.
Yes, sir, it is there.
It's there. So please, at this point of time, if you guys want any, if there are any further questions or any further elucidation that you want, which I've not been able to cover, I'll be quite happy to do that. Go ahead, Swati. What are the questions?
Sir, my question is, sir, is a controller under the Indian Patents Act, is he empowered to determine the inventive step aspect of an invention? Because, sir, the requirement of determining the inventive step, it is coming under Section 25, which comes in oppositions. It is not there in any section before that. So my question is, during prosecution, I mean, can the controller even determine the inventive step of the invention?
All right, Swati, that is what he will. He has to determine whether there is an invention or not. See, of course, his first determination, his first thing is under the examination is under rule. He has to determine whether there is an invention. All right. That you will agree, Swati? He has to determine whether there is an invention. All right.
Yes, sir.
Now, under what is an invention? The invention must be that it must not. The invention an invention can be firstly either a product or process. Number one, and go to the definition. So he is exercising his rights or the power that you said under Section 2 of the Act for determining whether it is an invention. And for doing that, he has to look at both novelty, whether it is new or an original, whether it is new, and whether it enjoys an inventive step. So he is not doing it under 25. He is checking whether it is an invention under Section 2, Swati. All right?
Okay, sir. Yes, sir. Right. Because, sir, I was asking because there is a specific section dedicated to novelty. However, no such section is there for inventive step. That is why I was asking, sir.
There is in section 2(1)(j).
Sir, but is it not like the bibliography? I mean, is section 2 not like a bibliographic detail which says what is what? But later the further sections are
But
elaborated.
it defines an inventive step. No, it defines. So he's
That it
required
does,
to.
sir.
He has to look at section 2 and define and determine whether it is an invention. Of course, the inventive step argument is now has been when IPAB was there. If you read some of the judgments of the IPAB, the IPAB has said that if the invention was considered as inventive in the USA or Europe or 3 other jurisdictions, how the controller cannot consider, because inventive step is a very subjective treatment. It is in the mind of the controller. Whether there is an inventive or not inventive is in the mind of the controller. Now, whether that controller, for example, is he a person skilled in the art? But these questions you cannot normally take up in your your arguments in office actions. You always have to be very humble before the controller, as Mr. Patre, who's going to come after me, is going to take. All right. Very important to be very humble before the controller and not sort of argue too much with him or challenge his integrity or challenge his qualifications. Right.
Yes, sir. Thank you, sir.
Just a few. I can take 1 or 2 more questions if they are there. Otherwise, I'll pass it on to the next speaker.
Afternoon, sir.
Good afternoon, Kushi.
This
Yes,
is
Srishti.
Srishti. Sir, I had this doubt yesterday. Can you explain method claim and apparatus claim again, sir?
A method claim and an apparatus claim. We are going back to, you are telling me what is the difference between Rama and Sita, but I'll tell you again. All right. And what is the difference between an apparatus claim and a method claim?
Yes.
Hello?
Yes, sir. Yes, sir.
Apparatus claim is a claim for a set of elements. A set of elements or devices, for example, as I said, an MRI device or MRI apparatus, which will have a whole number of devices: the controller, the MRI machine, the imaging, the capturing machine, the photographic plates under below. This would be the apparatus. The apparatus claim is a series of nouns, a series of elements. Now, a method claim is a series of verbs, which means doing things, activities. A method claim will always be a series of activities: receiving, sending, transmitting. So these are the kind of things. So a method claims would be action words, action things, action elements which are new. In both cases, in your apparatus claim or a method claim, both of them have to be new. All right, but apparatus claim will have a series of devices. Methods claim will have a series of method steps of working that apparatus. Let's say it may relate to the same apparatus, but it will be the workings of the apparatus. A method claim is not concerned with the elements of the apparatus. An apparatus claim is not concerned with how the devices work. It's only a list or a menu of devices and how they are interconnected with each other. Right?
Yes, thank you, sir.
Sir, this is Meghdut Bhattacharya. How
Yes.
you describe the future profession of patent attorneys in the light of new digitization, when many data are available internet, and most of the chartered accountants and lawyers are also under pressure because the softwares are gradually eating up the jobs of many of the professions. So what is going to be our impact?
All right, Meghdut. I believe you are a patent attorney yourself.
Yes, sir.
All right, good. And where are you based? What is
Calcutta.
your
Calcutta.
what is your technology background, Meghdut?
I am an electrical engineer plus advocate.
Electrical engineer.
Yeah.
All right. Yeah, Meghdut. I'm an electronic engineer and an advocate also.
Okay, sir.
So we are in the same boat. But what I did was that I would try and learn as of course I did electronic engineering several years ago. So I took effort and tried to learn the new techniques of ML and AI and blockchain. So I would recommend that you start even as attorneys. We should learn. We should be aware. We should be aware of the new technologies, and at least in your lifetime, that is, I would say the next, let us say, 70 years or so, 50 to 70 years. A robot is not going to be able to replace a patent attorney.
Okay.
So you're not going to be replaced as long as you do your specifications well, as long as you write them well, because there is still that last semantics that is called patentees. It is very difficult for a robot to study patentees. They may be able to write in English, but they will not be able to do this as part of your profession. So it's still going good. In the last 2 years, in fact, we have had so many inventions. In fact, the inventors have been more active because they had no other work to do.
Right, sir.
All right.
Okay.
So all the best, Meghdut. I hope you do well in your profession, and please, it's a extremely great profession. And if I were to select again, even today, I would not select any other profession except what I am today.
Right, sir. Okay. Thank you,
Okay,
sir.
Meghdut.
Thank you. Yeah.
Welcome.
One
Hello,
question.
sir.
Yes, ma'am.
Hello, sir. Wonderful.
Yeah, is this Harita or Shivani?
Harita, sir. Yes,
Yes,
sir.
Harita, tell
I
me.
have a doubt, sir.
Yeah,
Can
tell
we
me.
have a mechanism claim, sir? And can you explain the difference between a mechanism and a method claim?
No, mechanism would be a mechanism would be considered as a product claim. It is
Okay,
like a
okay.
device. A mechanism would be considered as a product claim and not a method claim. So a mechanism for doing instead of a device, that is another word that you can use. Instead of a device, I can call a mechanism for doing something. The patent examiner will allow it. The mechanism would be actually generally I would use the word mechanism for example, as part of when I'm drafting a part. For example, if I have a tractor. So if for example in the tractor has a mechanism for connecting a trailer to the tractor, and then I will describe the elements. There may be a gooseneck, there may be a pin, there may be there may be various other features. All right. I think I have now run out of time, and I would now request.
One last question, please. This is Shivani.
Shivani will take it up tomorrow. Okay, Shivani.
Okay, sir. Okay, sir.
Tomorrow at the end, just note down all your questions and send it by email, and I'll ask them to send it. So please note down, right?
Sure, sir.
I will now ask Mr. Patre, Mr. Arvind Patre, who was the Joint Controller of Patents, ex-Joint Controller of Patents, and he is a gold medalist from in chemistry from the Nagpur University, a brilliant scholar in chemistry, and a brilliant controller when he was a controller. He has heard so many oppositions, and he is very extremely complicated matters, and we are proud to have him as one on our team as an important and integral member of our team. Mr. Patre, over to you, sir.
Thank you so much, sir, for your kind word. Sir, I have to share the first screen, then I will miss it with the
Yes, I believe you have to share your screen, sir. Who is part of the co-host, can they give Mr. Patre the rights? Video.
Sir, is the screen visible?
Yes, it is.
Thank you, sir, for your kind word. I am no longer a controller. I am with the Miss R.K. Diwan and Company, a simple patent attorney now.
Okay.
Sir, our topic is today is the Miss amendment of the Miss patent applications and the patents in India. In patent prosecution, pages include from the Miss all the communication to and from the Miss Indian Patent Office, from the Miss timing of filing of the patent application to the grant of the patent and amendment is most important, and amendment is the most important part of it. In every stage, amendment has been carried out, and it is a very, very important part of the means prosecution stage. Now, existing Patent Act is the means 1970 Act, which came into force on 26 April 1970. It has been amended so many times. So many times it has been amended. It means last time it has been amended in the 2005 under the Miss GATT or WTO entry of the Miss India. And important chapter there is the Miss TRIPS. On the Miss obligation of TRIPS, we have amended the Miss main section in the Miss Patent Act. Earlier, section 5 was there in the Miss Patent Act, which has been deleted, which deals with the only process patent is available in the drugs, pharmaceutical and chemical sector. And now, after the Miss amendment or deletion of that particular section, all types of patent is available in the even in the Miss chemistry sector, pharma sector, or drug sector. So why I am referring to the Miss these amendments of the Act? It is relevant to the Miss amendments also. At the time of the Miss 1856 Act to the 1911 Act and afterwards 1970 Act, language of the Miss particular section related to the amendments was almost remain unaltered during the Miss even after the Miss change in the Miss different acts. In 1970 Act provides the for amendments of the application for a patent, complete specification, or any related document at any time, either before or after of the grant of the patent. If the amendments to the patent and applications are governed by the section 59 and 50, 57, 58, and 59 of the Act, which has to be read with, along with the Miss Rule 14, 81, 82, and 83 of the Patent Rules 2003, which stipulates that how the amendments can be made. Additionally, Section 78 empowers the controllers to correct the Miss any clerical errors either upon a request made by the Miss person interested or even without such request because section is just like that. Section 70, it is a power given to the Miss controller to amend the Miss particular any type of application, specification, or any type of error that has been power given to the controller under section 78 of the Act. But section 57 and 58 and 59, it relates to the Miss voluntary amendments, not related to the Miss power of the Miss controllers. I refer one case law to you. In case of the Miss Press Metal Corporation Limited versus Nosirji Sorabji Pochkhanwala, it was held that while section 78 empower the controller to correct the clerical errors, it does not empower the controller to make the amendment suo motu. Means though language of the Miss Act is just like that, it is a power given to the Miss controller, but controller cannot act suo motu. It has to be followed. It is to be governed by the section 57 Act. Means it has to follow the Miss procedure of the Miss Act and rules.
Sir, your slides are not moving.
Yeah. I'm coming, sir. Just it is a background. This is just a background. Okay. I am referring to the section. I am coming to the that particular slides. Okay. This position was also confirmed or also mentioned in the another landmark case in the AIR Engineering Limited versus Controller of Patents, wherein High Court of the Delhi drew a distinction between the section 58, which deals with the power of the controller to correct the clerical errors, and the power to be exercised under section 57 regarding request for amendments of an application made by the patentee. In this case, the learned judge held that the purporting to exercise powers under section 78 of the Act, there cannot be any amendment of the application for which the procedure under section 57 must be followed. Means even if power is given to the Miss controller to correct any type of clerical errors, it is to be governed by the section 57 only. So it has to follow the procedure laid down under the section 57, 58, and 59 of the Act. Yeah. In today's topic, we will cover the amendments to be made in the different type of forms, specification, documents, any type of documents. Limitations on the amendments allowed, and examples, case laws related to it, and question answers. When to file the amendments and why the amendments are required. Amendments are required in the every stage, every prosecution stage of the patent application. It can be amended either before the grant of the patent, or during the prosecution stage, or even after the grant of the patent, amendment is possible. To the application, it can be made in the application, complete specification, or any other related document, including amendments of the priority date of the claims. Even the priority date of the claims can be amended, but one has to be cautious by amending the priority date of the claim. We will see in the next of the slides why it is important one. However, in some of the cases, in certain cases, controller shall not pass an order allowing or refusing the amendments in the particular application or specification. Why? When any suit before the court for infringing the patent is pending before the court, or say High Court, District Court, or maybe IPAB, but now IPAB have been scrapped. We can say about the before the court or any type of High Court if it is pending. So controller shall not pass order. Why he should not pass the order? Because it is pending before the higher forum. That is why he shall not pass any order until decision is received from the higher forum. Any proceeding before the High Court for revocation of the patent is pending, whether the suit or proceeding comment before or after the filing of the application to amend. Even before filing of the application, it is already filed before the High Court or any type of court, then controller shall not pass any order regarding the amendment in the particular application. Yeah. Most important thing is, one is voluntary amendment, which is governed by the section 57 and 59 of the Act. And another is suggestive amendment. Suggestive amendment means which is suggested by the authority to you carry out the amendments in the particular type of document. That is the suggestive amendments. Voluntary amendments is carried out by, as the word suggests, voluntarily means it has been carried out by the applicant himself or suggested by the applicant himself to carry out the amendments. For voluntary amendment before the grant of the patent, an application in Form 13 may be filed stating the nature of the amendments and full particulars of the reason for which the application is made. In Form 13 itself, it has been stated that what is the nature of the amendment has been suggested by the applicant. That is to be reflected in the Form 13. Form 13. Again, that should be accompanied by a markup copy to recognize what type of amendments need to be carried out in the particular document, and along with the clean copy. Why it is required markup copy and clean copy? Because suppose you are carrying out the amendments on page 10 of the specification. You have to suggest the particular word where or addition of particular lines in the specification. These and these amendments are required, and that is to be in markup copy, so that controllers can easily recognize that these and these amendments are suggested by the applicant and whether it is allowable under the Act or not. And again, you have to file the clean copy of it along with the markup copy. Even though it is allowable or not allowable, that is the part of the controller. Still, you have to file the clean copy of it. Why it is required? Because if you have filed originally the specification containing the 30 number of sheets, say, and replacing and markup copy has been filed for the page number 10. Now that sheet is to be replaced with the particular clean copy. That is why it is required the markup copy and clean copy. And because you are voluntarily amending the specification or any document, so cost is there. Cost is there means for a filing fees for the Form 13 is required in the voluntary amendments. In what type of documents amendments is possible? As per the Act, it is possible in almost all type of documents filed before the Patent Office. Say, for example, voluntary amendments can be carried out in the bibliographic details. Bibliographic details means what type of application it is, what is the date of filing, what is the priority date. All these are coming under the bibliographic details. To correct the typographical error, or record the change that may have occurred after the filing of the application. Even title, as per the requirement of the patent rules, title should be within the 15 words only. 15 words only. If someone has filed the more than 15 words, that time controller may suggest to amend the title by within the limit of the 15 words. So title can be amended by amending particular, and it should reflect correctly, technically correct to the field of technology to which pertains. In abstract also, you can amend. What is abstract? Abstract is a concise summary of the invention, the technical field to which your invention is relates, along with the means use of that particular use in the particular technology. And as per the means patent rules, it should be within the means 150 words of the limitation is there. 150 words. It should be within the limitation. So if that exceed other than means more than 150 words, then the controller suggests that you reduce this means abstract to the means 150 words. Or sometimes what happen? Sometimes you disclose the means technology there, but that is not correctly disclosed. That means what type of technology disclosed in the means specification and abstract. That is not means matching. Or correct technical features are not reflected. That time controller suggests you amend the means abstract in the means specific abstract. That is filed separately, though it is means filed along with the means specification. Another is specification and drawing. Here also you can correct the means typographical errors, translation error, or to incorporate the actual facts subject to the provision of the act. Most of the times what happens in the drawings, generally the client, generally applicant insert the means names of the means particular parts in the drawings, but that is not allowable. So it should be reflect with the means numerals only, with of the particular part. So they suggest you amend the means drawing only reflecting by the numerals only. Similarly, any type of amendments possible in the specification also. That we will deal in the next of the slides. And most important part is the claims part of the specification. Please remember that you are not getting the monopoly for the whole disclosure in the specification. You are getting the monopoly for the claims part only. Your boundary is restricted to the wordings of the claims. So most important part is the claims part. So any type of amendments carried on the claims require the expertise. If anything is deleted from the claims part or added in the claims part, that may be a challenging part in the next prosecution stage. That is why it is the most important that claims should be amended very precisely, cautiously. And what type of amendments can be carried out? Typo error, translation error, reference numbers, delete and merge, amend claims, subject to the provision of the Act. Voluntarily, you can suggest the amendments of the claims. Even the deletion of the claims is possible. We will so any type of amendments is possible in the claims also. Even the deletion of the claims is possible under the voluntary amendments. We will recently in 2016 the patent rules has been amended. Earlier, while entering in the national page, we have to file all the claims in the national page also. Suppose in the PCT application, there are more than 200 claims. And you know what is the filing fees of per claim in 1600 for the legal entity, 1600. Suppose there are 200 claims in the PCT, and that has been entered in the national page. So you have to file the fees for the 200 claims. But in 2016, claim that rules has been amended, and now deletion is possible. Deletion of claims is possible. Which type of claims you can delete? The claims which are fall under the section 3, section 4, use claims, that is not allowable here in India as per the Patent Act. That is why it is possible to delete. Suppose 100 claims are deleted and filing fees is 1600 per claim. So 1,60,000 you can save by deletion of the claims by entering in the national register itself. What is not allowed? Amended specification should not include any matter which was not in substance disclosed in the original specification. So these are the important parameters in section 57. We will deal with the section 57 in next slides. And amended claim should fall fully within the scope of the original claim. For example, if description is related to method of making the ethanol from the sugarcane, suppose description says that you are preparing the ethanol from the sugarcane, and in description you have not mentioned that it is also made from the maize corn. Now you're supposed to add the maize bird corn in the specification by way of voluntary amendment. Whether it is possible, because you have not earlier disclosed the maize corn, only you have disclosed the maize sugarcane, method of preparation of ethanol from the sugarcane. Now you wish to disclose the corn also there in the specification and file the amendments for it. Whether it is amendments are possible? No, it is not possible because it is not disclosed in the earlier filed, initially filed or originally filed specification. That is what it will alter the scope of the initially filed, originally filed specification disclosure. So it is not possible to add the particular word like corn herein. So amendments is not allowed in such type of amendments. Similarly, claims mention preparation from the plant material. Suppose claims mention preparation of the something from the plant material, say alcohol from the plant material, and subsequent claims mention only sugarcane and not claim the corn, even though it is corn is there in the specification, but you have not claimed in the claims part. Now sugarcane is there, plant material is there, plant material is the broad thing by scope, but in subsequent claims you are saying only about the sugarcane, not about the corn. So voluntary amendment is possible. We add the word corn in the claims. No, it is not possible, even though it is in the specification or description. But amendments is not possible to add the particular word in the claims part, because you have limited your boundary to the particular words only, sugarcane only. You can bring that word instead of plant material. You can describe that plant material as a sugarcane, but you cannot describe it as a corn, even though it is in the part of the specification. So corn has been disclaimed by you. You yourself disclaimed. I do not require the claims on the corn. So you have disclaimed that part. So you cannot add that particular word corn in the claims. So that is the disclaim. Interestingly, section 57.5 specifically allows the amendments of a priority date of the claims also. In essence, it provides an applicant with the opportunity to correct the priority date if the patent application had been filed with a wrong priority date. However, in one of the case laws, Nippon Steel versus Controller of Patents, Delhi High Court has observed that applicant tried to disown the first filing date as priority date and requested the controller to change the priority of the application under section 57.5 to the filing date of the subsequently filed PCT application. The High Court did not address the issue of whether such change in priority date was admissible because the application was deemed to have been related to that particular application only, withdrawn due to the non-submission of the request for examination in the prescribed time period. While the various provisions under section 11 that is related to the priority. While the various provisions under section 11 related to the priority date of the claims would have to be earlier date, the question as to whether an applicant may be allowed to disclaim a first filing date and change the priority date to the filing date, that is the depends on case to case, varies from case to case. It depends on the situation. If you request for the change in the priority date to the latter date, say latter date, in case of the post dating also, sometimes due to the some of the material is not there in the specification, important material, you post date the application. But if someone has some type of priority already appeared in the prior art, that time you will be the loser one. So if you wish to amend the priority date, then you should be very cautious whether you should search whether already such prior art is available or not. Then only you amend the priority date. Voluntary amendments after the grant of the patent. Even the after the grant of the patent, voluntary amendments is possible. The controller shall publish the nature of the proposed amendments. Why it is publication is required? Because it is a notice to the third party who are using such type of technology that such and such amendments has been made, applied in the particular technology, and someone is already using such type of technology, nearby technology. That time he may oppose, public can oppose that such amendments is not possible, or no. And that is to be filed on the Form 14 within the 3 months from the date of publication. The controller shall notify to the applicant and shall give to the applicant and to the opponent an opportunity to be heard. It is just like the opposition proceeding. They file the document before the patent office. Again, that will be notified to the applicant, and applicant will reply on it. Again, controller fix the hearing, just like the same opposition proceeding under Rule 57 and 63. What is suggestive amendments? The name itself indicate suggestive amendments. It is suggested by some authority, maybe examiner, maybe controller. On the direction of the authority, you are carrying out the amendments. That is why it is a suggestive amendment. To comply with the directions of the controller after examination in response to the pending objection, e.g. rejection, for example, rejection of the application. To comply with the requirement raised in the FER, first examination report, where the application relates to more than one invention. Just now you have disclosed with the sir that regarding the division application or unity of invention objection is there. So amendments is possible. To overcome the objection on the ground of the anticipation, you may be aware of these words: anticipation, novelty, inventive step, industrial applicability. These are the important words in the patent terminology. So anticipation means your invention is novel or not, considering the novelty and inventive step definition. That is the anticipation. To overcome objection on the ground of the potential infringement, the suggestive amendment is possible. So it is coming from authority. So you have to carry out the amendments. Otherwise, you have to convince the controller why such amendments is not necessary. As it is suggested by the controller, that is why it is not required, cast is not required, and you have to carry out the amendments as suggested by the controller. Application shall be deemed abandoned if the requirements are not complied with within the 6 months. And this is related to the FER. If Patent Office has issued the FER, that reply to the first examination report has to be filed within the 6 months. If it is not filed within the 6 months, then it is abandoned. Again, amendments after the acceptance but before the grant. By the direction of the controller in pre-grant opposition. Suppose someone has filed a pre-grant opposition in the patent office before the patent any particular application. So what is the remedy with the applicant? Remedy with the applicant is that he can amend the claims considering the type of citations given in the pre-grant opposition or even in the FER. The amendments are possible. That is the suggestive amendments. In opposition proceeding, where it is shown that the applicant obtained a this is the obtained a part of the invention from the opponent. The controller may require that the specification be amended by the exclusion of the part of the invention. Suppose two friends are there. They are carrying out the research on the same project. They are friends. But A and B, both friends. But A has filed the application before the patent office without informing to the B on the same technology. Now, what is the remedy left with the B? Because both are worked on the same project, he should have a part of that application. Ideally, it should be filed on the name of the A and B, but only A has filed. Now, B will approach to the controller on the ground of obtaining. He has obtained the particular part of the specification from me. So, what is the remedy left with the controller? Then controller will fix a hearing accordingly. So, what is the project accordingly, and what are the project done by the particular part done by the A, and what is the particular part done by the B? And if it contains the part of the B also, that time controller remedy is that controller may direct A to remove the particular part from the specification. But sometimes value is depend on that part also. So it depends. So amendment is possible that way also. The applicant may himself seek to leave the amend the specification with view to overcome the objection. Sometimes what happens? Objection raised by the controller, that is to be required to be met. And for that, amendments need to be carried out. Voluntarily or to raise objection, to meet the rate objection. So it is possible to amend the claims that time also. Amendment during the revocation proceeding. Where the revocation is possible? Revocation is possible in the three stages. Either when the patent is granted and post-grant opposition is filed, that time revocation is possible. If it is filed before the higher forum, say IPBR, High Court, then revocation of the patent is possible. The patentee may be allowed to amend his complete specification instead of revoking the patent. Generally, what happens when the opposition filed or it is before the Miss High Court. They allow, if amendment is possible, if it is by narrowing the scope of the that particular claim, they generally allow to amend the complete specification instead of revoking the patent. So priority is given first to the amend your specification, amend your claims instead of revoking the particular patent. Controller is entitled to appear and to be heard in such proceeding. Why controller is allowed or entitled? Because he has granted that patent. So his say is important. That is why he can appear before the higher forum, whether amendment is possible or not. Nowadays, even in the courts are taking the help of the scientific advisors also. Scientific advisors are appointed by the patent office, and list is maintained in and that is available on the our patent office website. Copies of orders allowing the amendment shall be transmitted to the controller, who shall cause an entry to be made in the register. Suppose the patent has been granted, but now it is revoked by the higher forum. So what is the remedy? And that has been already entered in the register of patents. So the High Court will not do the entry. He will direct the controller. You patent has been revoked, so you make the entry in the register of patent that it has been revoked and now available to the public free of charge. Yeah, limitations on amendments. Section 59(1) of the Act states that it is a very beautifully crafted section, Section 59. No amendments of an application or a patent or complete specification or any document relating thereto. Any document relating thereto shall be made except by way of disclaimer, correction, or explanation, and no amendments thereof shall be allowed except for the purpose of incorporation of the actual fact, and no amendments of the complete specification shall be allowed, the effect of which would be that the specification as amended would claim or describe matter not in substance disclosed or shown in the specification before the amendment, or that any claim of the specification as amended would not fully fall within the scope of a claim of the specification before the amendment. Section 59 is the most important section for the amendment, where condition has been let down. By what way you can amend your any documents? By way of disclaimer, that is to limit the scope of the claim. By way of correction, that means to correct the obvious error. By way of explanation. This explanation means of adding up particular terminology related to it, or explanation of anything appear in the particular claim. Suppose, for example, say the chemical name Teflon. Teflon is appearing in the that claims part. Teflon is a trade name. So trade name is not allowed. So then controller suggests that you replace the Teflon word with the chemical name. So client will replace, or applicant will replace the that Teflon word with the chemical name. No amendment shall be allowed except the purpose of the incorporation of the actual fact. In addition, the proposed amendment should be wholly within the scope of the original claims. original claim. For example, just now I have given this example to you. If someone has given alcohol, defined the alcohol in the claims part. Now, in the next subsequent claims are defining the what type of alcohol it is. It is methanol or ethanol. Say it is saying the only ethanol. Now you cannot change the scope. Now earlier you have defined the ethanol only. Now you cannot further add the word methanol also. So that will alter the scope of the originally filed claims. So it is not possible to alter the scope of the originally filed claims. No amendments of the complete specification which broaden the scope of the claim shall be allowed. It is not allowable to add the which is not earlier disclosed in the specification that to be added further in the specification. So that type of amendments is not allowed. So it is very important while drafting the specification initially that should be drafted very precisely, taking into consideration all types of possibilities. No amendment shall be allowed if the amended claim does not fall within the scope of the unamended claims. If someone wishes to add the particular word in the already existing claims, if it is within the scope of the that particular claims, all these claims, it is possible to amend the claims. But if it is not within the already existing claims, you cannot add the particular word in that particular claim. An amendment that limit the, what is disclaimer? Disclaimer is that an amendment that limit the scope of the specification to a sublimit which was within the original claim is a disclaimer. Suppose if some steps are there, a heating step is there, which require the particular range of temperature 100 to 200 degrees centigrade. Now, due to the prior art, if I wish to amend the that particular temperature range from 100 to 200 range to within the very narrow range of 50 to 60 degrees centigrade, is it possible? If such type of examples is there, that is within the scope. So, if such type of example is there, such type of disclosure is there, then it is possible to limit that particular range. So what is it? You are disclaiming the wide range and narrow down your scope to the particular range in the temperature. Similarly, other parameters also you can limit. Converting an optional requirement to an essential is also a disclaimer. Sometimes what happens in the claims optionally comprises so and so part also. But from the specification, it reflects that it is the essential part and controllership direct. So if it is converted into the essential part, that will be considered as a disclaimer also. Even that deletion of the claims, earlier claims, which was existing in the initial filing, that has been deleted, that will be considered as a disclaimer. One important disclaimer case is a Gillette Safety Razor Company versus Luna Safety Razor Company. You may be aware of the story of the Mac 3. It has the invention with the huge investment, $750 million, and they have filed a suit in that case. So there is a tough competition in the any field of technology. So matter in this application is patent claimed the use of very thin flexible blades in the razor. Very thin means for the means good to get the means good shaving. The specification was wide enough to cover both safety razors also with curve holders for the blade and non-safety razors also with straight holders. An amendment to limit the scope to safety razors was allowed by way of disclaimer. Is it possible? Quite possible. Quite possible. Earlier there was a means wide scope. Now he narrowed down his scope to the means particular safety razors only and disclaiming the part of the non-safety razors. So it is allowed. And it has been allowed in the means Gillette safety razors versus non-safety razors also. Correction. What do you mean by correction? Correction means to remove the errors or mistakes that have been made in the preparation of the specification. While preparing the specification, you may have made some mistakes. That is possible. If it is a clerical error, if it is not altering the scope, then it is possible to carry out the correction. Does not include the correction of the error of judgment. If the mistakes is apparent on the face of the specification, there is no need to evidence to prove the mistakes has been made. Suppose you have given the formula of benzyl alcohol. Somehow you have described the whole specification on the line of the benzyl alcohol, but somehow in some places if O is missing out of OH, that functional group O is missing. Then what is the remedy? That is the actual fact. Actual fact. So amendment is possible to add that particular O by filing the Form 13. If the mistakes is not of this character, evidence will be necessary to establish that there was a mistake. Suppose in the chemical cases, if very big formula is there, Markov structure is there, and something is missing from that particular Markov structure, then what is the remedy? You have to show that such type of the compounds fall within that particular Markov structure has the such and such meaning. So that is the evidence you have to show that according to the examples, this is not possible in the Markov structure. So you have to bring the evidence that such amendments are possible. That is a correction for its allowability. Correction of the obvious mistake is possible. Sometimes while preparing the translation errors may be corrected. However, in certain cases, original documents be mistranslated may be required to be corrected. That is possible. But sometimes you have to bring the particular translation authentic document from translator also in that cases. Spelling mistake, typo error, incorrect appearance of the special character due to the formatting issue may be corrected. That is possible, but possible. When the correction sort amounts only to mere changes in the nomenclature, it may be allowed. Suppose there are some chemical in the specification, and you have given the you have not given the IUPAC name or generic name. Then controller may direct that nomenclature is not there in the specification, only just Formula 1 reference is there. Sometimes you direct, you amend it to the particular specific name. So that is possible. Where amendment completely alters the identity of the compound claimed, it cannot be considered as a mere alteration in nomenclature. But while correcting the particular compounds, it is to be considered whether it is mere alteration or whether it is changing the scope of the initially filed compound. If it is changing the scope of the initially, if suppose OH group is there, Now you wish to replace with which functional group is there. Now you wish to replace with the means carboxylic acid group. Then it is not possible to carry out the corrections because you are changing the scope of that particular invention. This is the EP case in the matter of T10891. The invention related to the container closure arrangement. According which according to the claims was unstressed. Please see the particular word. The invention related to the container closure arrangement, which according to the claim was unstressed. Here, whereas it was clear from the description that this part was in fact under tension. So it is exactly opposite. What is claiming? It is saying it is a closure arrangement is unstressed. But in description, it describes the fact that it is under tension. So it has to be rectified. Opposition board concluded that it was contravention of the Miss Act when an incorrect technical statement, which was evidently inconsistent with the totality of the disclosure, was replaced by an accurate statement of the technical feature. So it has to be replaced. Unstressed has been replaced with the under tension.
May I ask you a
another
question, sir?
way of carrying out the amendment is explanation. What is explanation? To explain the invention more clearly, remove ambiguity, should not lead to the claiming or description of a new matter. Oh, sorry.
Sir, I had a question, sir.
Claims? Yeah.
Sir, sorry to
Hello?
interrupt. I had a question, sir.
Yeah.
May I ask you, sir?
Yeah, definitely. We will take the question answer after the finishing this all the slides. We will take the question answer.
Sir.
That will be okay. Explain. What is explanation? To explain the invention more clearly and to remove the ambiguity. Should not lead to the claiming or description of a new matter or any variation in the scope of the claims. Generally, explanation involves the addition of the words. Just now I have given this example. Suppose that particular word alcohol is appearing in the specification, not in the claims. Alcohol is appearing in the claim. But what type of alcohol, it has not been explained in the subsequent claim. So it is a very wide scope. So that time, what is the remedy? You have to add that particular, you have to explain that particular word. What is the type of alcohol it is? Alcohol, whether it is ethanol, whether it is methanol, that is to be explained. In certain cases, where the deletion of the certain words removes uncertainty and increase the clarity, that is also deletion is possible and will be considered as an explanation. We will take the one case law here. AGC, TAT, Glass, Europe, South Africa, SA versus Anand Mahajan. Decided on 10th September 2009. The plaintiff wanted to insert the phrase sensitizing material, typically tin, to the granted claim in the patent. The patent is already granted, but now applicant wish to insert the particular phrase sensitizing material, typically tin. So what type of claim it was? It was a mirror with no copper layer comprising vitreous substrate, a sensitizing material, typically tin. It is the new addition which is not earlier there, and at least one material. And third step is a silver containing layer on the surface of the substrate, and fourth step is at least a paint layer covering the silver coating layer. Now, Now, what is decided by the court, Delhi High Court, allowed the post-grant amendments on the ground that the amendments is merely a clarificatory, elaboratory in nature, so does not alter the scope of invention. Why it is not altering the scope? Because you are adding the means particular. Already that particular steps are existing there in the means claims. Now you are explaining that or further limiting the scope of them in that particular claim. So that is what it is allowed by the court. The entire invention works in the means particular 3 steps. Sensitizing process. Just now I have shown the means earlier slide that it exists in the means 3-4 steps. Sensitizing process step, activating process step, and silvering process. The word, what is the means court observed? The word sensitizing material prima facie appear to be related to the first process and do not in any way lie outside the scope of the invention. Anyhow, it is the limiting the scope of the means earlier claims. That is why it is allowable. And the word typically teens simply narrow down the scope of the invention. Both the words are narrow down the scope of the invention. So that is why it is allowed by the High Court, Delhi High Court. Amended specification should increase in the scope. What is the increase in the scope? Amended specification should not claim or describe any matter not in substance disclosed prior to the amendment. Just now I have said the amended specification, you have specification already filed with the before the patent office and describing the particular features. Now you used to add further features in the means already existing features. So if it is altered the scope of the means that particular invention, then it is not possible to amend the specification. So that will be considered as an increase in the scope of the invention. Similar in the means claims also. If you have already disclosed the means particular type of solvent is there in the means particular step, say you have used the means solvent chloroform. Now you replace that word chloroform with the solvent word. So that is not possible, but because that increase the scope of that claim. So it is not possible to alter the scope of the means initially filed set of claim. It is the increasing the scope of the initially filed set of claim. The amendment should be such that it does not increase the scope of the invention. Just now I have explained. For amendments sought before the acceptance, the controller may refuse or prohibit the application if it involves, for example, sometimes what happens? You have filed the application before the patent office, and there are so many lacunas in the means specification. And while replying to the means first examination report, you have added so many parts in the means specification that is not existing earlier. So that time, it is not possible to alter the scope of the initially filed specification, but you have added so many sentences or description in the specification. That time, what the controller suggests, coordinate your application to the date of filing of that particular reply means while replying to the first examination report, then your date will be shifted to the means that particular date. That is the port dated. So it is not possible to add the fresh subject matter. Suppose similarly the means you have amended the means object clause. Suppose your object is purification of the particular compound. Now you are saying that no, my object is not the purification, it is the some other yields, obtaining the more yield only. That time deletion of the object clause is not allowed. Unjustified broadening of the main claim. If main claim is the important claim, first claim is the main claim, or any independent claim. What is independent claim? the claims which is not dependent on the means other claims, either independent claim. If you have already disclosed particular elements A, B, C, D in the first claim, now you wish to delete the means D element from the first claim. So you have already disclosed that one in the means claim 1, but now you wish to delete that D element from the means claim 1. So it is not possible because you are widening or increasing the scope of the initially filed claims. So it is not possible. Another case we will take, that is the Tecum's Products India Limited, Hyderabad versus Kirloskar Company Limited, Pune. Opposition succeeded on the ground of insufficient description under section 25(1)(g). The original specification describes, now holes are on the suction or discharge muffler. Suction muffler or deployed. Holes is on the means suction muffler or discharge muffler. After the proposed amendment, it has replaced that sentence particularly in the claims. Holes are placed down the inlet tube of the suction muffler. Instead of suction muffler, he is now defining that holes are present on the means inlet tube instead of the suction muffler. That may be part of suction muffler only, but he is changing the scope of the means that particular claims. So it is not possible. What is possible? And that is not allowed by the court. The nature of amendment that are admissible are considered by the Intellectual Property Appellate Board also. In one of the important case, Salve Plur GmbH versus DuPont. In this case, DuPont sought to amend the specification after Salve filed a revocation of DuPont patent under section 3D and 3 as non-patentable subject matter. IPAB in its order mentioned that it is possible to make the amendments to the specification for overcoming objection raised under the section 3D and 3.
Sorry.
Yeah.
Just read it. Okay.
Yeah. Okay. Can I carry on?
நானே நான் வாங்கினேன். எவ்வளவு வச்சிருக்கா? சரி. Okay. ஓ அது பெருசு.
Sir, your slide is not changing.
No problem. This is the miss. That is not there in the slide. That is not there in the slide. This is the miss. That is not a part of the slide. That is why I have not changed that one. That is the miss just for your reference case. This is reference case. So it is whether it is possible to amend the miss when the miss objection is raised under the miss section 3D or 3. If the amendments were related to showing the technical advance due to the combination of the elements, and if the amendments complied with the requirement of the section 59, that is, were either made as a disclaimer, correction, or explanation, then it is possible to amend by way of explanation that is decided by the IPAB. The extent to which amendment would be allowed by way of explanation remains to be seen. For example, if an element or process is depicted in the mid-drawing, suppose some elements are there in the mid-drawing, but you forget to mention in the specification, description part, whether it is possible to add that particular related drawing part, whether you can explain that drawing part in the specification? Yes. And no also, because sometimes controller allow it that is already there in the drawing part. So you describe that particular part in the drawing in the disclosure. Disclosure means description part. But sometimes some controllers are very strict, take the strict that you have not disclosed at all in the specification. So I will not allow it. It depends, varies from controller to controller practice. Yeah. In the matter of the PCT National Phase Application 6001 NP 2013, it is stem cell related inhibitor filed in the name of the University of Michigan. A PCT National Phase Application was filed on the 4 July 2013, based on the PCT application number so and so, dated 10/1/2012, claiming priority from the US so and so application number, dated 10 January 2012. See here. When the application filed in the national page means say in India, it is filed in 2013. And when the PCT application was filed, 2012. And what is the priority date? 2011. So priority date is always earlier. Then it is the international filing date. And then when you enter in the national page, that is the filing date of that particular country, say in India. The Indian national page application contained all the original PCT claims 1 to 30. PCT में 1 to 30 claims file किया था, ठीक है? But he entered with the all these claims 1 to 30. Form 13 was filed on 9/1/2015 for claim amendments along with the clean copy of claims 1 to 10, where the 1 to 24 were deleted. Say, how many claims were there earlier? 1 to 30 claims was there. Now he is out of that 1 to 24 claims are deleted. Okay, it is not a problem. So how many claims remain? Should remain only six claims, which is the part of the earlier 30 claim that should remain, and that should be claimed. Only that should be claimed. But what he has done, he has filed the claim amendments with the 1 to 10 claims. 1 to 10 claims. The remaining claims were amended and renumbered. And new dependent claims 4 to 6 were added. New claims were added. That is why it is 1 to 10 claims. What is the objection raised? An objection raised that Form 13 would not be allowed as no markup copy was submitted indicating the amendment as per the Section 57. What is the requirement of Section 57 and rules 81 to 84, 81? You should file, when you file the amendments on the Form 13, it should be filed along with the markup copy. But applicant has not filed the markup copy while filing the Form 13. So what the learned controller has communicated to him, that originally filed claims which is filed before the PCT and same claims has been entered in the India also. So Form 13 cannot be allowed as no markup copy has been submitted indicating the amendments of the under Section 57. Claims as originally filed have been considered for examination. Controller is quite right. But that is not the single reason. Other reasons are also there. Objection of the claims amendments were retained in the hearing notice also. Same objection was retained also. And what is communicated in the hearing notice? The amendments in the claims are not allowable under Section 15A1, 59 as the addition of the new claims. You are aware that only by 3 ways you can amend the claims. Claims are any part of the application, by way of disclaimer, by way of explanation, by way of correcting the clerical error. So addition of claims is not there. It is not fall within these 3 categories, addition of new claims. So what the controller has communicated, the addition of new claims is beyond the scope of the provision of Section 59 of the Act. And also claims of the specification as amended do not fall only within the scope of the claims of the specification before amendments. And whatever amendments carried out by the applicant, earlier 1 to 30 claims that has been amended to 1 to 10 claims with the new addition of the claims, that is not, that alter the scope of the initially filed set of claims. So that is not allowed by the controller. And he has given the decision on it. The applicant agent in written submission, this is the part of the decision. Applicant agent in the written submission to the hearing stated that the support exists in the PCT claims and are support in the PCT application, but the claims 2 to 4 are newly added claims voluntarily, and the applicant agent has not given any proper explanation or reason for the instant amendments, and also has not mentioned by what way these amendments are carried out. The voluntary amendments are also not filed in the prescribed manner. The amendment by way of addition of new claims is not allowed as per the provision of section 59(1) of the Act. Mere support in the means, even though it is supported by the specification, but addition of the new claims is not there because it is not there in the initially filed set of claims. If it has been, what happens in the situation if these 1 to 30 claims has been amended before the PCT, say in the you may be aware of the ISA, IPA. If it has been amended, and with that amended set of claims, if he has entered in the India, even if the addition of claim there in the or some rectification there in the before the ISA or IPA, it is possible. It is possible, but here it is not possible. Here he entered with the same set of claims, 1 to 30 claims that has been again reduced to the 1 to 10 claims, but it includes the further addition of the claim. So that is why it is not allowed by the controllers and it has been rejected. It is rejected. It is a part of the decision only. In view of the above, non-allowability of the amended claims 4 to 6 as per the provision of section 59(1) of the Act, amended claims so and so is not patentable as per the provision of the further. Another claim is there in the added claims which is fall under section 3I. 3I means there is a non-patentable section that is related to the method of treatment. So that is also not allowed by the controller and repeat the case. Appeal to the IPAB. The University of Michigan versus Controller General of Patent Design and Trademark decided IPAB clarified the well-settled principle of law on amendments of the claims that no new claim may be allowed and the amended claims cannot be go beyond the scope of the claims of the specification before the amendment. If you alter the scope of the initially filed set of claims, that is not possible, that is not allowable. The whole question is whether the claim inserted is new and whether it defines the new feature not defined in the body of the claims. If it is the new claims, it is not possible to allow it. If it is added the new feature, it is possible to allow. If it is already added in the existing claims by way of explanation, then it is possible to allow. If it is added the new feature, that is already there in the claims part or maybe in the specification, that is possible to allow. IPB found the dependent claim 4 to 6 to be permissible as it only further defined the features already covered in the principal claim and had sufficient basis in the description. IPAB refused to allow the claim 5 beyond the scope of the principal claim. Now, I just explain about the by 3-way you can amend the specification. By 3-way you can amend the specification. If you wish to amend the address of the applicant or nationality of the applicant, then just file the form 13 and you can rectify the errors in the address or nationality of the applicant or name of any error is there in the that can be rectified. That can be during the pendency of the application or after the grant also. When you amend the name of the particular applicant, that time documentary evidence is required because you are amending the name of the applicant and documentary evidence from whom it is required. Say if it is a company, legal entity, then company appears. Register of company side, that documentary evidence is required to change the name along with the form 13. Complete specification included a claim to overcome the controller's objection after the grant. And similarly, in patent proceeding also that complete specification can be amended. So it is possible to amend the specification or any documents even after the completion of the proceeding before the patent office, after the grant of the patent also. Yeah. Now we can open for the question and answer. Hello. Hello.
May I ask a question, sir?
Yeah.
हाँ बिल्कुल बिल्कुल पूछिए.
सर एक क्वेश्चन था मुझे सर 59(1) के तहत हमें डिस्क्लेमर या बाय वे ऑफ करेक्शन या by way of some kind of a clarification we can make changes under 59(1) of the Patent Act.
Right.
So my question here is, if the controller or if the first examination report already states that you have clarity, conciseness issues and inventive steps issues, and for that we have amended the claims, that is basically we have put the dependent claims in the independent claims, that is the claim limitations to overcome the prior art.
Yeah.
So
Correct.
will that come under amendments which are not under 59? Because I got a hearing notice which is saying that it is voluntary amendments. From a practice point of view, I want to understand whether those are beyond the scope of 59 or within the scope of 59, sir.
All the amendment, whatever you carried out, even it is under the objection of the controller, in the convert in the FER or hearing notice, whatever amendments you are carrying out, it is within the limit of ambit of the section 57 to 59 of the Act. 57, whatever, even it is the part of the FER only. If it is communicated by the controller in the FER, and you carrying out the amendment to meet the requirements raised by the controller, that is also under the that is also governed by the section 57 and 59 of the Act. So whatever amendments you carry out, even under the obligation of the controller side, it is under the 57 of the Act. 57 of the Act. Yeah, carry on, madam. Any other question?
Hello, sir. Thank you for thank you, sir. I'm Parag. So I have a question with respect to USPTO. If I can go ahead.
बोलिए.
या तो मैंने इंडिया में पेटेंट फाइल किया है and which is carrying priorities of Indian patent, and then in US I have filed and say suppose it has some errors which are not known at the time of filing, and then I am filing amendments correcting those error and especially in claims. So
अच्छा,
what
आप
are
बोल
the
रहे हैं वो जो
chances?
यूएसपीटीओ के सामने जो फाइल किया उसके बारे में बोल रहे हैं कि इंडिया में फाइल किया उसके बारे में बोल रहे हैं?
USPTO.
Okay, हाँ बोलिए.
So what are the chances USPTO will allow those amendments?
हाँ, जैसे हमारे यहाँ पे सेक्शन है ना, जैसे अमेंडमेंट्स के लिए उनके बाद भी ऐसे हुई है. यूएसपीटीओ इज मोर लिबरल दैन द इंडियन ऑफिस आल्सो. तो अगर वहाँ पे सेक्शन है और आप जैसे अगर स्कोप अल्टर नहीं कर रहे हो, ऑलरेडी जो अगर स्पेसिफिकेशन में अमेंडमेंट है जो ऑलरेडी मींस एग्जिस्टिंग जो उसका स्कोप है उसको अल्टर नहीं कर रहे हो, तो इट इज जनरली वर्ल्ड वाइड क्राइटेरिया. जनरली जैसे हमारे यहाँ पे ये सेक्शन 57, 59 एक्ट है, एक्ट में है, वैसे उनके यहाँ पे भी पर्टिकुलर सेक्शन है. अगर वो विद इन द, लेकिन लैंग्वेज तो लगभग सेम ही होगी लगभग, में स्कोप अल्टर नहीं होना चाहिए. इनिशियली फाइल जो आपने जो किया हुआ है उसका टाइपोग्राफिकल एरर है, तो देयर आल्सो यू कैन अमेंड इट, नॉट ए प्रॉब्लम. लेकिन अगर जो ऑलरेडी आपने फाइल किया हुआ है वहां पे यूएसपीटीओ के सामने, उसका स्कोप अगर आप चेंज कर रहे हो, समझे कि नहीं, जो ऑलरेडी उसमें नहीं है वो डाल रहे हो, तो दैट इज नॉट पॉसिबल टू अमेंड इन यूएसपीटीओ आल्सो. It is almost the same criteria in here also, India also, and USPTO also. Yeah.
Okay, sir. Yeah, thank you.
Sir, मेरा एक सवाल है आपके लिए. Sir, my question is, why does the Indian Patent Office controllers do not allow multiple dependencies of claim? आजकल सर काफी बार ऑब्जेक्शन आता है कि
अच्छा मैडम,
one claim is dependent.
क्या नाम है आपका?
स्वाति सर.
स्वाति मैडम, you are working as a patent agent?
जी सर.
पेटेंट एजेंट, ठीक है ना. आप विचार करो, मैं आपको समझाता हूँ, हिंदी में पूछाता हूँ, मैं हिंदी में समझाता हूँ, ठीक है। अभी आपने क्लेम्स 1 to 10 क्लेम्स लिख दिया आपने स्पेसिफिकेशन में, ठीक है, फाइल कर दिया, और क्लेम नंबर सी के 5 ऑनवर्ड से आप बोलेंगे इट इज डिपेंड ऑन द क्लेम नंबर 1 to 4, ठीक है, ओके, मल्टीपल डिपेंडेंसी दे दिया, तो उसका
ठीक है
मीनिंग
सर।
क्या हुआ मैं आपको समझाता हूँ, ठीक है। अभी क्लेम नंबर 5 के बारे में हम लोग बात करेंगे, ओके। क्लेम नंबर में बोल रहे हैं process of making the alcohol, preparing the alcohol as claimed in claim 1 to 5, okay.
सर आप कोई मैकेनिकल या इलेक्ट्रिकल एग्जांपल देंगे? मैं इलेक्ट्रॉनिक से हूँ।
मैकेनिकल में एलिमेंट्स होते हैं, यहाँ पे प्रोसेस स्टेप्स होते हैं, सेम थिंग, ठीक है। इट इज रेफरिंग टू द मींस क्लेम नंबर 1 to 5, 1 to 4 अर्लियर क्लेम्स। नाउ अभी क्लेम नंबर 5 का लैंग्वेज जो है 1 to 4 को रेफर कर रहा है, तो उसमें कौन से क्लेम अकोमोडेट हो गए मुझे बताइए। हाउ मेनी क्लेम्स आर
क्लेम्स 1 to 4, 1 to 4
मींस जो क्लेम नंबर का स्कोप क्या हो गया, इट इंक्लूड द मींस इट हैज टू बी, उसका लैंग्वेज ऐसा नहीं होगा 1 to 4 नहीं होगा, एनी ऑफ द क्लेम्स रहेगा, एनी ऑफ द क्लेम्स 1 to 4,
एनी वन ऑफ क्लेम्स 1 to 4,
एनी वन ऑफ द क्लेम्स। उसका आपको कितना स्कोप मिल रहा है आपको, यानी एक क्लेम के लिए आपको मल्टीपल क्लेम्स आपने फ्रेम किए हुए, इंस्टेड ऑफ फाइलिंग देम सो मेनी क्लेम्स यू हैव फ्रेम्ड देम सिंगल क्लेम, ऐसा इट इज नाउ डिपेंडिंग ऑन द 1 to 4 क्लेम्स। नाउ उसमें 1 नंबर का क्लेम भी ऐड है, तो 5वें नंबर का जब आप रीड करोगे, प्रोसेस ऑफ मेकिंग द अल्कोहल अलॉन्ग विद द क्लेम नंबर 1, ये एक सिंगल प्रोटेक्शन हो गया। पहले तो क्लेम नंबर 5 का अपना वो कौन प्रोटेक्शन है, नाउ इट इज टू बी रीड विद द मींस क्लेम नंबर 1 आल्सो, समझ गए। नाउ उसको छोड़ दीजिए, एनी अदर क्लेम्स को। नाउ अनदर वो 2 पे भी डिपेंड है, 3 पे भी डिपेंड है, 4 पे भी डिपेंड है, ठीक है। फिर से आप जब उनका लैंग्वेज पढ़ोगे, प्रोसेस ऑफ प्रिपेयरिंग द अल्कोहल एज क्लेम्ड इन क्लेम नंबर 1 to 4, तो उसमें क्या और रहेगा, 1 नंबर भी आ गया, वो एक स्कोप हो गया, 5+2 वो भी उसका दूसरा स्कोप हो गया, ठीक है। 5+3 क्लेम नंबर है, 5+3 उसका डिफरेंट स्कोप हो गया, सो इट इज ए मल्टीपल स्कोप इज देयर, ठीक है ना। तो पेटेंट ऑफिस के लिए, इंडियन के लिए नहीं, इवन मींस वर्ल्ड के दूसरे पेटेंट ऑफिस के लिए भी एग्जामिन करना मुश्किल हो जाता है, ठीक है, और आपको वाइड प्रोटेक्शन मिलता है। दैट इज व्हाई they raise the such type of objections. That is why they do not allow the multiple. But sometimes they allow, sometimes they do not allow. ठीक है, मैं आ रहा हूँ, बस just I taking the glass of water, I am coming. Yeah, carry on. या किसी को कुछ क्वेश्चन है और?
Sir, I have a question.
हाँ बोलिए मैडम।
Yeah. In the granted patent document, like in certificate of grant, is it possible to have a name of the inventor?
I know madam, provision there. Provision there. There means you have to file means format. Format is for that particular addition of the means name in the certificate of the inventor. You can add that one. If you file the means format, then along with the means piece, then it is possible to add the name of the inventor along with the applicant in the means certificate. They will mention the name there.
Okay, so Form 8 is for that. I mean, getting the names of the inventor in patent certificate, grant certificate.
Yeah. For that purpose only.
Okay.
Under section 28. Yeah.
Thank you, sir.
Yeah, any other thing?
I have one more question, sir, if I may ask you.
अच्छा, मुझे पहले बताइए कि वेदर जो मैंने समझाया आपको, वेदर इट इज अंडरस्टैंडेबल और नॉट?
यस सर, समझ में आया सर, इसीलिए तो क्वेश्चन है सर।
ठीक है, ओके। नहीं मोस्ट इफ यू आर रिलेटेड ऑलरेडी रिलेटेड मींस पेटेंट, it is okay for you, but if someone is not from his patent background, that time it is very difficult.
नहीं सर, वो समझ में आया सर, वो कोई दिक्कत नहीं है सर।
हाँ ठीक है, ओके बोलिए।
ओके, क्या मैं अपना प्रश्न पूछ सकती हूँ सर अभी?
हाँ बिल्कुल।
यस सर। सर, I got a rejection which is in other requirements, sir. It actually says that the various definitions of the invention given in the independent claims are such that the whole scope of the claim is not clear and concise, and there are plurality of independent claims. So which makes it difficult to determine the matter. So in
Right,
this
right.
kind of a rejection, how would I overcome this kind of rejection?
Whether it is
Actually,
only
sir,
objection or already reviewed, application is already reviewed or only just it is objection.
it is reviewed, sir. It is in FER. In FER, I got
Yeah,
this.
okay, such type of okay. Because
So
generally in though it is not there in the means act also, but if you have means so many set of claims, but generally they what happens if it is the means within the single inventive concept, but you are claiming the so many independent set of claims. That time they object.
but actually, sir, my understanding is that there is no limit to the number of independent claims and the set of dependent claims which you can draft, if as long as it is bound by the single inventive concept, as well as if you are paying the
You
requisite
are
fees
correct.
for
You are
it.
correct, madam. Correct. Definitely correct. But when you frame them is so many independent set of claims, just like the miss I have explained before, miss so many addition of the miss claims. Just now I have explained. So what is the meaning of it? You are claiming the miss first claim. Say the miss I am claiming the miss method of preparation of the particular chemical compound. Now you are claiming the means another independent claims instead of depending it on the means claim number one. That time what happens? Interpretation of the means all these claims will be different. That is why they object that you generally in Indian patent examiners are very reluctant to allow the means so many independent set. Generally they allow the one or two, most of the time three also some of the times, but some controllers are very rigid that they do not require the means so many set of claims in the means single patent application. Sometimes what happens, it is may attract the means section 10(5) of the means act also, may according to language of the means that particular claim. So they are very reluctant to allow the means in so many independent set of claims in the single case. If suppose you frame the means so many independent claims in the means single application, what will happen? Its scope will not be defined. Its scope will not be defined correctly. That is why they do not allow them in so many independent claims in the single application.
Okay. So in that case, can I file a divisional application for the set of claims which I am withdrawing?
No, madam, no. Because it is not direct. The controller is not saying directly that it is a distinct invention or unity of invention का objection लगाया क्या उन्होंने? Unity of
नहीं
invention का
लगाया
objection लगाया? नहीं लगाया ना?
नहीं लगाया
हाँ, तो ये बोले अगर आपको लगता है कि it may be plurality of invention, if you can show that there is a plurality of invention in two independent set of claims, this is the distinct. So you may request the controller. You have not raised the means objection under the means unity of invention and only independent set of claims. Shall I rectify it, or whether it is possible to divide it? Unless and until they raise the objection of unity of invention, it will be very difficult to allow the means divisional application. But if objection in the hearing notice, you request it. You object on the ground of the unity of invention in the next stage of prosecution, maybe in the hearing stage, then you have a liberty to file the divisional application. But sumoto, if you have filed, that time it will be the prerogative of that controller whether he will allow it or not. It depends on that particular controller only. So you request controller independent set of claims, either you rectify it, defining the particular scope only, and request the controller, please, whether it is fall within the unity of single inventive concept. If it is not fall within the single inventive, kindly raise the such objection so that we have liberty to file the divisional application.
Okay.
Yeah.
Okay, sir. Thank you for your clarification, sir. From the practice point of view, I had some questions and I'm
But that
glad
depends
that
on
this has been.
depends on controller to controller. It depends on
Yes,
controller to
sir.
controller.
Subjective. Yes, I
Practice
totally agree.
in India, practice varies from controller to controller.
Yes, I
Yeah.
get that. Okay, sir. Thank you so much
Where are you
for your
working, madam?
clarification.
Where are you working?
Sir, I'm actually working in Prometheus Patent Services, sir, from Hyderabad.
Oh, okay, no problem. Okay, thank you.
Thank you, sir.
Yeah, any other questions?
Sir, I have a question, sir.
Only.
Sir, nowadays the controllers are raising an objection that they want the application number of the particular case to appear in the power which is being submitted.
Power of attorney. You are speaking about the
Yes,
power of
sir.
attorney.
Yes, sir, power of attorney. So I want to know, I mean, is this a valid requirement, sir? Because from what I see, that Form 26 does not require application number to be indicated there.
Yeah, madam, I am coming to that. Power of attorney is of two types. Either you give them power to them that particular agent for a single application, or you give them general power for them that particular applicant. Say in Reliance, Reliance is a big client. So what he gives them is general power of attorney. General power of attorney to them is any particular agent. But if it is related to the single application, simple power of attorney, that time generally there is sometimes application number is there, or sometimes application may not be there. You ask that controller if it is simple power of attorney. At the time of your requirement said that it should be filed within the 3 months after filing the application. And generally what happens, you file that power of attorney with the application also. At that time, I don't have the application number, and I have to file with that particular power of attorney. How can I enter the application number in that power of attorney? Correct?
Sir, the controllers are actually raising this objection in cases where a general power of attorney is filed, sir.
If it is simple power of attorney, but you have a specification with you, you have a title with you, that time generally you have to mention the title of that particular application. That is sufficient. Title.
No, sir, but I'm asking for cases where general power of attorney has been filed, sir.
No, not only in general power of attorney. When original, in that case, original power of attorney has been filed in the some earlier case. Only you have to refer that particular number in which that original power of attorney has been filed. That you have to refer in the subsequent applications. That is the only requirement.
Yes, sir, but the controllers nowadays insist that we have to give application number.
Because I will not comment, but these are the new controllers. They don't know the about the these actual accounting. They are not well expert in the that particular law. Only they are expert in the Patent Act only, because it is not related to the Patent Act. It is related to the other act. So that is why they are not aware about these provisions. That is not correct, madam. Referring to the particular application number, it is not a correct process. Correct. Okay.
Thank you, sir.
Just you can say that how can I report the application number when I file that application at the time of filing of that application? How is it possible? Not possible. Yeah.
Sir, they say that general power of attorney cannot be given for a future application. That is what the controllers say.
Sir, आप बोलिए उनको ये बोलना है जनरल पावर ऑफ अटॉर्नी, दैट पावर इज नॉट derived from the Patent Act. It is derived from समझ रहे है कि नहीं? उसका प्रोविजन दिखाइए, जनरल पावर ऑफ अटॉर्नी का लैंग्वेज क्या होता है उनके. ठीक है,
ठीक है सर, थैंक यू.
या carry on. Shall we close the session now? Hello. Hello.
Yeah, no one is there.
Monopoly.
We can close it now, I think.
Yeah. Okay.
But
Thank you.
there,
Thank you,
I
participant. Thank you so
host
much.
is not.
So much.
Thank you.
Thank you. Thank you. Thank you so much.
Thank you, sir.
Sebelum,